Next, if you scroll your socials for UK news this week or look at almost every newspaper front page, there's been daily headlines about the significance of a landmark ruling. From all the papers, we can see essentially it comes down to what happened at the Supreme Court. It's a biological, the definition of what is a woman, that is a biological woman. The legal definition of sex too is binary. And that doesn't include transgender women, biological men who identify as a woman. There are immediate societal adjustments and changes being made or reviewed when it comes to single-sex spaces in public places, hospital wards, prisons, public toilets, sports club. This was the considered judgment on Wednesday by Lord Hodge, who set out the essential points of an 88-page ruling.
The unanimous decision of this court is that the terms woman and sex in the Equality Act 2010 refer to a biological woman and biological sex. But we counsel against reading this judgment as a triumph of one or more groups in our society at the expense of another. It is not. As I shall explain later in this hand-down speech, the Equality Act 2010 gives transgender people protection not only against discrimination through the protected characteristic of gender reassignment, but also against direct discrimination, indirect discrimination, and harassment.
So this was a judgment setting and settling a 7-year legal fight by the campaign group for Women Scotland. It goes back to a law brought in by the Scottish Government, who set a target for women to make up 50% of all public boards to tackle underrepresentation of women, and included in the definition of women trans women with a gender recognition certificate. And the 4 Women Scotland campaigners argued it was unlawful to include trans women under the Equality Act 2010. They lost the fight in the Scottish courts until it was finally settled this week, as we heard there, at the highest court in the UK. This was the reaction outside court.
The decision of this court is that the terms woman and sex in the Equality Act 2010 refer to a biological woman and biological sex.
Well, these were campaigners watching the scenes in Edinburgh, some of the support group there. Let's bring in Helen Joyce. She's been actively involved in supporting this campaign. Former journalist, bureau chief editor of The Economist, the author of Trans When Ideology Meets Reality, and director of advocacy on sex matters. Helen, it is great to have you on the programme this evening. And you've said...
Thank you for inviting me on.
Well, earlier this week you said you were worried you might lose this case. And talk to me through the past few days that you've experienced as a result of this ruling.
Goodness, it's actually quite emotional looking at that. I was in the courtroom, and before the judgment was read out, they warned people in the room to be silent and not to respond, which of course is correct. You're in a courtroom. So we weren't able to do what the people in your video there did, the women who were watching by video link from Edinburgh, who were able to stand up and cheer. What there was instead was a sort of a polite at that word biological, and we knew we had won. So it was an amazing moment, as you say, the culmination of a 7-year battle brought by grassroots campaigners for Women Scotland and supported by women all over the UK that often seemed like a hopeless cause because we were up against the Scottish Government, we were up against the government in Westminster, though it wasn't part of the case, we knew it agreed. We were up against most of the legal establishment who all thought that men who have certificates saying they're women count as women for the most important anti-discrimination law in the country, which of course makes a mockery of the idea of sex discrimination. And yet the Supreme Court justices saw it the right way. They understood what discrimination law is for. The group that I work for, Sex Matters, we were able to submit. We were able to do both oral and written submissions. And sitting in the court and hearing the judge use the word cogent, which is sort of judge speak for really, really excellent, about our submissions was possibly a highlight of my life.
I have the quote here. So Judge Patrick Hodge, he cited your work, Sex Matters, in his judgment. He said this, quote, "The charity argued cogently for a biological interpretation of the word woman." And that must feel like a personal vindication for you. These terms that you've used in the past, you've been called bigot for, you've been given interviews that have been censored on YouTube as well, removed from YouTube. That for you, I think you've described it as kind of resetting the default.
Exactly. So, to give your viewers a very short recap of some very complicated law, the Equality Act 2010 brings together almost all anti discrimination law in the UK. Race discrimination, sex discrimination, age discrimination, etc. And the sex discrimination bits date from 1975, from the Sex Discrimination Act. If you fast forward from 1975 to 2004, you get a law called the Gender Recognition Act, which for the first time gave people legal documents that registered them as having the opposite sex to the sex they actually had. They had to have a diagnosis from a doctor of gender dysphoria and have spent 2 years living using documents and so on that change a name and things like that. They don't have to have surgery or medical treatment. Then in 2010, the Equality Act brought all these laws together. And the question was, is the Gender Recognition Act something that changes your sex in the Equality Act, or should we still use the definition in 1975, which of course was biology?
Mm.
And it's turned out that allowing the Gender Recognition Act to affect the Equality Act is like sticking a spanner in the works of it. It made everything not work properly. And that's what the judges recognised, that the only way for protections against sex discrimination to work for women, to work for lesbians, is to take the biological meaning. It was a massive personal vindication for me and for many, many other women working in this fight.
I wonder what you think the wider impact will be when we've got institutions now saying that they are reviewing, they're going to set out new guidelines in accordance with this ruling, not just for the UK, but what you think with European countries grappling with this issue politically when it's found itself at the heart of a culture war, whether you think there's going to be a wider ripple effect here.
First, I'd just like to say that women's rights are not a culture war. This is not a war that women sought to fight. We would be very happy if everybody gave up pretending that human beings could change sex. We could all go back to living our lives quietly. We have to fight this because it takes away our rights. As soon as people stop trying to take away our rights, we will put our weapons down. But you asked more generally about how this would play out in other laws, for example, in the UK that register what sex people are, laws that govern where people go in hospital wards and police searching, what children are taught in school. In a lot of areas, there's going to be a lot of people who have to look through their policies and rip them up and rewrite them with biological sex instead of self-identification at their heart. And then you think one of the areas is sport. This is quite intriguing because in sport in recent years, men who identify as women have been allowed to compete as women. And of course, they have a huge biological advantage. But sporting competitions are international. So if one country decides that it's not going to allow men into women's sports, even if those men identify as women, then that is going to come up to supranational organizations, to the Olympics, and the next Summer Olympics are going to be in the US. So I foresee that just looking at what's happening in the UK will be meaningful, but also engagement via international things like sport will start to spread this thinking elsewhere, and other countries may decide to follow suit.
I mean, I mentioned the fact it's at the heart of a culture war, not because it's a women's rights issue, but it's kind of been almost grabbed and adopted and brought, whether or not, kind of kicking and screaming to use as somebody's argument against another. And I wonder whether there's a very, in fact, we probably overlook it. The second term here, not just woman, but sex is binary. Therefore, it puts the idea of a transgender person, there's not a third category, and yet we're in a situation where the British government, there's some advice to suggest that there should be a third space area for public toilets, etc. What do you make of that idea?
So within the Equality Act, there are 9 protected characteristics, as they are called, and sex is one of them, race, etc., like I said. But there's another one which is called gender reassignment, which is a fancy way of saying being trans. So people who are trans, they don't change sex. They still have their actual sex, and it's important to recognise that, for example, in their healthcare. But they have an extra, maybe a vulnerability or a need or a belief about themselves that it's right and proper to protect an anti-discrimination law. They shouldn't be harassed for presenting themselves differently, for having this belief system. They shouldn't be denied service in a pub or anywhere like that. They should be treated well, like everybody should be. But this is a particular issue. So what I think you're referring to is something that was suggested by Baroness Kishore-Falconer, who is the head of the Equality and Human Rights Commission. And what she was saying was that if a trans person isn't happy for some reason to use the facilities for their own sex because they don't identify with that sex, it may be best to offer a third single unisex option like a private toilet or a one-person changing room so that they don't go into the opposite sex's spaces because they're not allowed to, because they haven't really changed sex, and other people have rights and don't want them there because they're the wrong sex. I know I keep saying sex over and over again, but I have to emphasize that. But they too have rights, and they may need to have some special accommodations. It's not that they're a different sex or a third sex or a different category. It's that they may need special accommodations on occasion.
To suit them these, and the judge, is worth saying, he was at pains to say this is not a victory over one group over another group, and clearly there are big implications. You talked about it kind of resetting a default where women are prepared to speak out if they believe that there is a biological man in the changing room that they're not comfortable with, and over who has rights to that space. There are a number of prominent trans rights campaigners in the last few days say this strikes fear into them, the implications of this. One of them that they spoke to the BBC this week, this is Heather Herbert, who described it as fearful and a Trumpian move. Let's take a listen.
Well, obviously I'm disappointed. No judge can tell me who I am. If a judge was to tell you that you're not a woman, that you're a man, you would, it wouldn't change who you are. It wouldn't change how you feel. And it feels just like we're following in the footsteps of Trump's America.
I just wonder whether you think this needed to go to court in the first place, whether there should have been, over the course of the past few years, government-led, prime ministerial-led, clear indications of how government, how the situation would work. And I guess it's come to this, and it's also clearly taken on you emotionally to bring this case and the slings and arrows you've faced with it too.
Oh, you raise such a good point. This should never have had to go to court. If there had been leadership in politics and in regulators, it wouldn't have. So under the previous government, the Conservative government here in the UK, the organisation I work for, Sex Matters, organised a mass petition. We got 110,000 signatures. We had a debate in Westminster Hall in which I think about a dozen politicians spoke, begging the government to use a statutory instrument, a specific legislative tool, to make a one-line amendment to the Equality Act to make clear that sex meant sex, because trans people are separately protected under gender reassignment. And I mean, there were politicians in the government at the time who wanted to do that, but then the general election was called and that fell by the wayside. I think there's been a huge and widespread lack of accountability on this issue. It shouldn't have fallen to the ordinary women of For Women Scotland to do this work. They are unpaid individual campaigners who met on Mumsnet. They have jobs, family responsibilities. They had to fundraise. Often the money that came for these cases, a lot of it came from people who haven't got money to spare and made small donations. Women have had to fight to regain rights that should never have been taken from us. And at any point, it would have been open to politicians and to governments and to regulators to fix this without us having to do it.
Helen, let me mention something else to you, which is other legal terms, I guess, are still out there. Because if you look, for example, if you search your name, ChatGPT or Grok or Wikipedia, whatever, you are titled gender critical. Does that, therefore, as a result of this, need to be legally redefined?
Gender critical is just a shorthand. I think it started in some schools of feminism, and it's not really a very accurate term. I tend to say sex realist myself. I'm just somebody who accepts that there are two sexes, that sex can't change, and that your sex is meaningful and important in some aspects of life. For example, in sport. If you need to see a doctor, you might want to have a doctor of the same sex in your healthcare. Gender critical sounds like it's some big fancy philosophical position and people don't know what it means, but I don't think anyone defined it. Nobody said that this was it in law. It's just that it's become the word that's used. Basically, what I believe is just such an ordinary belief. I just recognise that human beings are mammals, and that as much as a man like Heather Herbert might like to be a woman, and I'm very sympathetic with him for being unhappy for being a man, he can't be a woman. We need to accommodate him as an unusual man, possibly a vulnerable man, but not as a woman. That's not me being mean. That's Mother Nature being mean.
Helen, good to talk to you this evening. Helen Joyce, who's been active in supporting this campaign, we've seen in the court this week at the Supreme Court, former bureau chief, a journalist, editor at The Economist and director of advocacy at Sex Matters. Helen, thank you.